And so I'm really lucky to have had a number of years to think about this problem of collaborative authorship. And during that time, I'm really lucky to have benefited from the intellectual generosity of my doctoral supervisor, Professor Graham Dinwiddie, my examiners, but also so many friends and colleagues, too many to name, who've challenged my ideas, who've pushed me to do better, and who've supported the project in a variety of different ways. So I'm really grateful to you more than I can say. Okay, so now what I want to do is just give you kind of a brief overview of the book, what I wanted to say, and why I wanted to write this book. So why this book about collaborative authorship? Well, collaboration, in a sense, is not a new theme. Collaboration has always existed. But with modern technology, it's becoming easier than ever before to work together. And collaborative work is taking on increasing economic and cultural significance. An iconic modern example is Wikipedia, right? Well known and relied upon. But large-scale collaboration now occurs in many different contexts. And groups are now capable of creating things that individuals can't create. So think about the work of like large scientific collaborations such as CERN. Yet copyright law, the main way in which we encourage and regulate creative work, has struggled to come to terms with collaborative authorship. Its principles have been criticized for being uncertain, and many have seen a disconnect between creative practices, creative realities, and copyright law principles. So the book is really trying to generate insights for how copyright law can come to terms with collaboration. And it does that by focusing on the example of large-scale collaboration, where some of these challenges for copyright law are particularly acute just because of the sheer number of people involved. And I think it's important that we get this sort of thing right, because ideally we want copyright to encourage collaborative creativity and not to be a stumbling block. So what does the book seek to do? It's essentially about the joint authorship test in copyright law. And I seek a framework for greater analytical clarity when applying the test, but also a framework that's better aligned with the expectations of creative communities. And I take a kind of inductive approach to this problem. And I use case studies. So I look at 4 case studies of what I'm calling collective authorship, large-scale collaboration, Wikipedia, Australian Indigenous art, scientific collaborations, and film. They're chosen to be kind of broadly representative of the variety of different ways in which these collaborations can occur. So we're talking about different kinds of copyright works in very different economic and cultural sectors, where authorship can be driven by different impulses. So they might be commercial, but sometimes they're spiritual, sometimes they're related to knowledge creation, like with science. Sometimes it's just for fun, in the case of Wikipedia. So I look at how authorship has been self-regulated in those contexts and what authorship means to those particular communities. And I try to contrast that to how the joint authorship test thinks about authorship, how it might apply to the works that they produce. And often it ends up being a fairly sort of hypothetical exercise because there aren't a lot of cases in this area. So I begin with a kind of doctrinal and theoretical foundation, looking at joint authorship in copyright law, starting off with the Section 10 definition of a work of joint authorship, which sometimes is broken down into 3 steps. And those steps can maybe give the illusion of analytical clarity, but in fact, the way in which the test has been applied in the cases has tended to be quite uncertain. And it's uncertain because the parts of the test can be run together. It's often not very easy to tell what's the exact reason why somebody is not a joint author or they are a joint author. We see in the cases a tendency to focus on the third limb, which is sometimes referred to as the authorship limb. So the question of whether or not a collaborator has made enough of the right kind of contribution. And that's where a lot, in fact, most of the joint authorship cases have been won or lost in the past. And in this respect, in the authorship respect, it's clear that joint authorship isn't just a question of quantity of contribution. It's also a question of the quality of that contribution. But insofar as there is some sort of qualitative requirement, it's not clear whether that relates to whether or not the contribution is significant, whether or not the contribution is of the right kind, what the relevant benchmark might be for that criteria of quality, Okay, so I think a lot can be said about the concept of authorship that underlies the authorship limb, and there's no time to go into authorship in a great amount of detail. But I think we can agree that authorship, generally speaking in copyright, is a low threshold. Right? It's a low threshold. It's the flip side of originality, generally seen to be a low standard. But when the authorship limb has been applied in the joint authorship test, particularly in some really well-known cases, it seems to have implied a higher standard than what we normally think of as original in the case of individual authorship. And so this is kind of the approach that has been taken in the case law, but we now have to consider the impact of the Court of Appeal's recent decision in Martin and Kogan, which provides a more structured approach, and I think it's an analysis that aligns a little bit better with the findings in this book. Okay, so I've suggested that the cases on joint authorship show a preference for a restrictive approach to joint authorship. And I suggest in the book that this is primarily for pragmatic, instrumental reasons rather than principled reasons. And that's because there's nothing in Section 10 that mandates a restrictive approach. Right? The wording of Section 10 doesn't assume that there should be a restrictive approach. And I suggest that this might have arisen out of a concern about the consequences of joint authorship, which is joint ownership of copyright. And that's really because of the inflexibility of the joint ownership rules. So in copyright, all joint owners must consent to any use of the copyright work. And so it's assumed that if we have too many joint owners, that might impede the exploitation of the work, hence the need to restrict the number of people who might count as joint authors. And in order to restrict the number of people that count as joint authors, you can see a number of different strategies used in the cases. And I want to focus on the strategies that I find to be the most problematic. And so the first is a tendency to concentrate authorship in the hands of those who have control over the creative process, or other dominant players, to the exclusion of minor contributors. And the second tendency is to concentrate authorship in the hands of the person with the most direct involvement with the fixation of the work. And this tendency to focus on the fixation, I think, is based on an unduly narrow view of the idea-expression dichotomy in copyright law. And at its worst, this narrow view can tend to conflate the fixation, so the material record or object the copyright is embodied in, with the expression, the intangible content that's actually protected by copyright law. And I think both of these approaches are contrary to fundamental copyright principles, and they have now, I think, been firmly rejected by the Court of Appeal in Martin and Kogan. Another tendency that I identify in the case law is a tendency to take quite an abstract approach and to be concerned about aesthetic neutrality. So I argue that underlying this is a proper legitimacy concern, that copyright subsistence should not depend on the aesthetic merits of the work. But sometimes this proper legitimacy concern can be translated into a more generalized anxiety about using aesthetic criteria in copyright decision-making. But in copyright cases, because of the nature of the subject matter, judges must, and in fact they do, consider aesthetic criteria. And I've got some examples of that on the slide. So I don't think that it's a problem per se that judges consider aesthetic criteria. What I do think is problematic is the failure to set out at which point in the joint authorship test those criteria should be applied, and to explain the point of reference for determining that criteria, which can lead to reasoning that has been criticized for being brief, superficial, or opaque. Okay, so that's a really, really brief tour of what I say about joint authorship. And then what I do is I move to look at various different case studies of joint authorship, of authorship in particular contexts. So I look at how authorship is regulated and what it means in these various different contexts. I apply the test to see where we would get, to identify gaps between the law and what happens in reality, and then identify insights from those gaps for copyright. And so I'm drawing together now what I think are the most important observations from all of those 4 case studies. So the first observation relates to the nature of collective authorship. And I observe that collective authorship is in significant ways different from of individual authorship. It's different because it necessarily involves a division of labour. And with that division of labour, creative control has to be dispersed. So many contributors necessarily retain some sort of significant scope for creative choice in relation to the shape of their contribution. So it's not really realistic to think of this sort of large-scale collaborative work in terms of one person who has a controlling mind, who controls what happens, and other people who just merely mechanically implement their vision. In implementing that vision, it always requires some creative choice. Another factor that's involved is because we have this division of creative labour amongst a large number of people, this results in some need to coordinate behaviour in relation to the common project. And this is often solved by appealing to social norms which embodied shared understandings about the nature of that creative process. Understandings such as what constitutes a meaningful or valuable contribution in this context, where does the creative process begin, where does the creative process end, and norms that just generally speaking regulate that creative process. The second observation is that authorship has an incredibly wide range of different meanings in different contexts. And there are lots of different attribution practices in relation to how authorship is credited. But one important commonality that you see throughout the 4 case studies is that authorship always signals a special status in a particular community. And quite often, the reputational rewards of authorship are more important to creators than economic benefits from copyright interest. The third main observation is that issues of copyright ownership actually tend to be pretty well managed with private ordering mechanisms. Right? Private ordering meaning mechanisms that don't originate from the state, but in particular things like contract. But there are some situations where private ordering doesn't work well, and that's where you have imbalances of power, and it's where you have private ordering that's imposed top-down in a way that doesn't represent the concerns of the authorship group. And the final observation that I want to focus on today is that actually collective authorship groups have a pretty complicated relationship to copyright law. But despite this complicated relationship to copyright law, it still, in all cases, serves as a valuable benchmark for authorship standards, what constitutes a good authorship minimum standard. Okay, so from those observations, I then try to derive lessons for how we should use this contextual information to understand how the joint authorship test could be applied. And I suggest that we need a bit of a recalibration in terms of how we apply the test. So the first lesson is that the pragmatic instrumental approach is probably misguided. That the concepts of authorship and ownership in the Act shouldn't be conflated. And that's because authorship entails more than just ownership. It also entails moral rights, non-economic rights. And sometimes those can be more important to creators than royalties because of the reputational benefits of having your name credited as an author. Also, this approach is based on an assumption that joint ownership rules make copyright impossible to deal with when there are lots of collaborators. But the case studies show that in quite a lot of situations, in most situations, these communities are able to use private ordering in a way that very successfully manages ownership issues. They show private ordering to be a flexible tool that can be shaped to fit the context in a way that legal rules just quite simply cannot, because they need to be general in their application. So this question of what we should do about joint ownership I deal with at the end of the book. And I suggest that, well, we should still look at the provisions in the Copyright Act again around joint ownership, and at least we should introduce a provision restraining joint owners from unreasonably withholding their consent, a provision that exists already on the continent. The second lesson is, I think an inclusive approach is much better than a restrictive approach for a number of reasons. So the first kind of fundamental one is it better reflects how collaboration actually works in practice. But it also better reflects copyright's own notion of the author as the creator of the protected expression, not as the controlling investor or instigator or orchestrator of other creators. It's a good default standard that incentivizes collaboration in line with copyright's its purposes to encourage and reward creativity. But even more importantly than that, because I think private ordering is really important in this context, it would give less powerful contributors an important bargaining chip that they can use in contractual negotiations. And having an inclusive standard would also encourage private ordering at earlier stages and actual explicit contemplation about the ramifications of authorship at the outset. So the third lesson is that the factual specificity of the joint authorship test, so the fact that it depends on the facts of the case, although it results in some uncertainty, because we can't really draw a lot of principles from those cases, it's actually a feature of the test, given the wide range of different ways in which authorship is understood and operates. So it's actually quite a good benefit. We want to keep that. The last lesson is that social norms governing collaboration actually provide quite a good source of information about the creative process. And because the dynamics of authorship vary so much between contexts, those norms are inescapably relevant to decisions on joint authorship, because it would be simply inaccurate to evaluate a contributor's contribution in isolation from its context within a particular collaboration. Okay, so what do, in summary, the case studies reveal about the best way in which to apply the test of joint authorship? I think you can summarize it in sort of two headings. So the first is that the joint authorship test should be applied inclusively, that the authorship requirement should not be stricter for joint authorship than it is for single authorship. I think the restrictive approach is wrong in principle. I don't think it aligns very well with copyright's purposes, and it's a poor fit for how creators themselves see the collaborative creative process. The second headline point is that the joint authorship test should be applied contextually, that judges should take the context as revealed by the social norms into account more explicitly when they answer questions of fact, right? Questions of law being another issue. I think this will help ensure the application of the joint authorship test is flexible, is transparent, and is credible to creative communities, and applies in a sense that really is accurate. Okay, but there are some limits when it comes to interpreting and including social norms in the application of the joint authorship test as a point of reference for aesthetic criteria. So although norms can be a valuable resource that help us understand the creative process, they can be defective, and there are some norms that should just be disregarded. So norms that are uncertain, norms that are unrepresentative, and norms that conflict with important policy goals underlying the law. Furthermore, I don't think that judges should simply adopt an authorial community's view about who is an author, because not all of those views will be compatible with the purposes of copyright law. So ultimately, authorship needs to be a legal question that's informed by the normative values, the purpose of copyright law. And the final chapter, chapter 8, sets out a proposed analytical framework for applying the joint authorship test in a way that's inclusive and in a way that's contextual. So I set out which parts of the test I think are questions of law, which parts I think are questions of fact, emphasizing that those questions of fact should be answered with regard to the specific creative context. So I think fundamentally what's needed is a refocus on the wording of Section 10, which indicates that a work of joint authorship involves authors working together, mixing or intertwining their contributions to create something that's more than the sum of its parts. And I think this conception of a work of joint authorship as more than the sum of its parts should inform the interpretation of the test. So it follows from this, and it follows also from the wording of Section 10, that the starting point for analysis should be the requirement for collaboration. And whether or not collaboration exists, I think, is best resolved in relation to the shared assumptions of creators. And then we can get a sense of what is the common design that creators see themselves as undertaking. And that common design can then usefully be brought to bear on the meaning of the other parts of the test. So what's a significant contribution must be closely tied to the creative context, and the common design can help us there. So I'm not saying judges should ask, does a particular authority or community consider someone to be an author, but they should ask whether their contribution is significant in the sense of being meaningful or valuable in that creative context. And finally, when considering whether the contribution is of the right kind, this is ultimately a legal question. It reflects the normative function of authorship and copyright law, and it should be inclusive or at least not more restrictive than the case of individual authorship. In this way, the joint authorship test can uphold copyright law's important purpose of providing good authorship standards or minimum authorship standards. So this inclusive and contextual way of applying the joint authorship test is intended to offer greater clarity. It's intended to be more closely aligned to copyright law's purposes, but also to creative reality of collective authorship and collaboration. And in my view, the Court of Appeal's recent decision of Martin and Kogan should be welcomed because I think it's a positive step in this direction. So thank you very much. And if anyone after the talk has any kind of thoughts or feedback, please send them to me via email. They're most welcome.
So Séverine and I are going to offer some brief remarks on your book and thoughts arising out of the book. And I should say, having just read Daniela's book, that was a very clear and wonderful synopsis of it. It was like a sort of
doesn't mean you
book
shouldn't
review.
buy it.
No, you should definitely buy it in order to read more. So it was a pleasure to read the book, and it's a pleasure to be able to speak about it. I thought I would do this through the prism of Martin and Kogan, because it's not often that you have a Court of Appeal decision on joint authorship, one so close to a book launch, and also one which cites the book that you're supposed to be discussing. And Daniela is being very modest in not referring to that, but I can sort of blow her trumpet for her. So what I want to do is just briefly talk about Martin and Kogan, because I know a number of you will have read the Court of Appeal decision, but not everyone will have had a chance to read it, given that it came out on the 9th of October. So this was about the screenplay for the film Florence Foster Jenkins, which was very successful, featuring Meryl Streep and also Hugh Grant. And Florence Foster Jenkins was a wealthy US socialite who loved music, particularly loved opera, and thought she was a very good singer, but in fact was pretty awful. And what happened here is that Martin and Kogan were in a relationship, a romantic relationship, for 3 years, from October 2011 to October 2014. And it was during this time that several versions of the screenplay were produced. But after their relationship had ended, the final version of the screenplay was produced, and it was Martin that entered into agreements in order for the screenplay to be produced as a film. Now, what happened is that Martin sought a declaration that he was the sole author and owner. And I'm not quite sure what precipitated that, but there was a reference to the fact that they'd had a couples therapy session where Kogan had raised whether she would be entitled to royalties. So whether at that point he thought, I better, sort of act swiftly, or whether it was something else. And Simon Malinitz is here in the audience. He may be able to answer this later. So this was a trial in IPEC, the Intellectual Property Enterprises Court. So it's tried in a particular way. And it was a 2-day trial, and it was heard by Judge Haycon. And in the end, he decided that actually Mr. Martin, the person who professionally wrote and was a screenplay writer, was the sole author and owner of the screenplay. Now, this went on appeal to the Court of Appeal, and there were a number of grounds of appeal, but I'm going to sort of summarize them under 3 headings which make sense to me. So the first is that essentially there was a key procedural error in the case. Now, what had happened is that the screenplay had been written over a period of time, and there'd been different versions. And Martin had accepted that Kogan had made contributions to a number of versions, but that when it came to the very final version, actually she hadn't contributed to that. And indeed, Kogan accepted that. So there was a question about whether we were talking about each version as a separate work, or whether in fact you could view this creative process holistically so that the final version was kind of the product of all of those earlier versions. And what happened in the case management conference is that it was pretty much agreed that this holistic approach would be taken, and that the contributions that had been made, provided you could show that they were in the final version, would be taken into account. However, at the trial and in the judge's decision, he very much focused on the lack of collaboration for that final version. So the Court of Appeal said, actually, this is a key procedural error in that you allowed the case to go forward on one basis, and then at trial you sort of did a switch and said, no, we have to look at whether or not you contributed to the final version. So the Court of Appeal was very critical of that procedural misstep. The second criticism and the basis for overturning the decision was the way in which the first instance judge had treated the evidence. So here the court had said, well, actually the judge had ignored key parts of Ms. Cogan's evidence, that he'd overlooked key features of her a witness statement and Annex A, in which she had set out or tried to set out all of the various contributions that she had made to the screenplay. So here the Court of Appeal found that key parts of the evidence had been overlooked and hadn't been weighed properly, and that actually the first instance judge had unfairly sort of treated Annex A, but that as a result there were no key findings of fact on whether they had collaborated, and indeed the nature of that collaboration. That in fact the only finding of fact on collaboration related to that final version, whereas in fact the judge should have been looking at collaboration over the course of the writing process. And in particular, no finding of fact as to whose idea the Florence Foster Jenkins project was. So there was a key discrepancy in evidence between whether this was something that was Mr. Martin's idea or whether in fact Ms. Cogan had to try and persuade him to do this. The third point, and this is the point that I think dovetails with Daniela's book, is that they were critical of the judge's approach to the law in some respects. So they weren't critical of all of his statements of legal principle, but they were particularly critical of the way in which he seemed to adopt an ultimate arbiter test. That if somehow you had the ultimate decision as to whether this material went in, this meant that you were the author. And as well, Judge Haken had developed a distinction in his judgment between primary and secondary skills, where primary skills were to the actual writing and secondary skills were more to contributions to the non-literal expression of the work. And here the Court of Appeal was critical of these, and in support of this criticism cited Daniela. Now, I should say Daniela in her book, in typical diplomatic style, says at page 39, it is difficult to escape the conclusion that this distinction between primary and secondary skills adds complexity without improving analytical clarity. The Court of Appeal cited Daniela, but was a little less diplomatic and said, the judge's distinction between primary and secondary skills in assessing contribution has no basis, either in the statute or in decided cases. To draw such a distinction tends to imply that less weight is to be given to ideas than to written words, when both are essential components of the work. In our view, the distinction is positively unhelpful. So they did cite Daniela in support of this, but I just wanted to clarify that Daniela was much more diplomatic in her criticism of these legal tests. So as a result, the Court of Appeal found that actually they didn't have the evidence to themselves revisit the application of the legal principles to the facts, that there needed to be key findings of fact, and so that this would go back to IPEC to be heard by a different judge. Okay, so I wanted to make a few remarks in relation to Daniela's book arising out of this case. So the first is, to what extent does this decision align with what Daniela has advocated in her book. And as I've just pointed out, in Daniela's book, she has been critical of the ultimate arbiter test and also the distinction between primary and secondary skills. And that is something that the Court of Appeal endorsed. But as well as that, when you look at the Court of Appeal decision, I think that they really do emphasize the importance of the collaboration element of the joint authorship test. And this is something which also very clearly comes through from your work, that actually you say it's important that this is given proper weight and consideration. The court is also mindful of being able to use the tool of different proportions of ownership to deal with different levels of contribution when it comes to authorship. And in Daniela's book, you very much advocate decoupling questions of authorship from ownership, and that actually, if you're looking at questions of fairness, this could be resolved at the ownership stage by different proportions. And this is something which we've seen in the previous case law, but the Court of Appeal really reiterated as a tool that could be used. So I think there are a number of ways in which what you advocate aligns with what the Court of Appeal has said, and so I think that's a really positive thing, and great that you've had that influence. But I do want to talk a little bit about where your work may not align with Martin and Kogan. And so I guess I would say your work in terms of the inclusive approach is very much being followed in Martin and Kogan. But I would query whether the contextual part of your approach is really going to be reflected in that judgment. So when it goes back to IPEC, the evidence that will be considered will be the witness statements of the parties involved and other documentary evidence. And none of that, from what I can tell, is really speaking to a context other than the individual context of those two parties. And in your argument for a contextual approach, you're advocating sort of, you have in mind, I think, sort of a much larger kind of collaboration rather than two individuals jointly authoring. And so what you talk about are norms of communities that are contributing to collaborative works. And so I suppose I wonder to what extent social norms would be relevant in a case like this, you know, and if they were to be relevant, what would you be drawing upon? Would it be, you know, the way in which creative couples who are in romantic relationships navigate this? Or is it, you know, given that she was playing the role of a dramaturg, do you then look at social norms in terms of screenplay writers and dramaturgs? And if you do look at that, and actually what it shows is that dramaturgs are often underappreciated and they're just seen as mechanisms for kind of providing information, what does that mean in terms of the normative question of whether or not that kind of contribution should be recognised? So I do think that as it stands and when it goes back to the first instance court, that element of your kind of contextual argument is really not kind of captured. And my queries are around how might that be if you're advocating it. And then I would say something that the Court of Appeal doesn't deal with and which you don't really deal with, and it's a small point, but it's a point that's always bugged me when I've taught this area, is this requirement that the contribution is not distinct. And I don't think you really come down, at least I didn't read you coming down one way or another on this in the book, and indeed the Court of Appeal sort of skirts over this. You cite a lot of US kind of comparisons when you're doing your analysis, and I just wondered to what extent sort of the US approach to joint works, where you have inseparability as well as interdependence, is the kind of approach that you're advocating, and also one that we see in French law with, you know, collaborative works. So then I would just say, crystal ball gazing, you know, what should be the outcome? So whether you accept Martin's evidence or whether you accept Kogan's evidence, what should be the outcome based on the evidence under your test? And I'll finish there.
Okay, so it's my turn. First, I would like to thank Daniela for inviting me here. I'm really happy to be part of this final stage, even very indirectly, because I met Daniela a few years ago, I think, in Cambridge, where we were discussing authorship already, and you were in the very first stage of your PhD, and I found it very promising, and I thought the team was really, really important and really timely, and I think that you have certainly fulfilled those promises, and you did it in a very excellent way. So I think that this is really a book that you should read. Don't be happy with the synopsis that she gave you. There is much more in the long feature, and you should go and read it, because I think it's really well done, very well written. It's very systematic, very straightforward. You don't lose time in that digression. So, there is something that I found completely amazing, that I really liked, that you didn't lose time in looking at theories of copyright. The lock theory, all this, the justification of copyright that nowadays you see in all PhD, in all books about copyright, and you decided not to do that. So thank you for that. But of course you could do that. You could also apply different type of justification or theories of copyright to your topic to see which one fits best. But I think that the fact that you didn't do that is also a relief to some extent. I think that what you have been doing here, even though you limit yourself to some extent to a UK law analysis, you have some insights from US law. I think it could be helpful also outside of the US, even though we have tests for joint authorship that might be a bit different, like in France. We have some resemblance, of course. Like, for instance, in France, one of the key factor in the test of joint authorship is the common inspiration or the spiritual intimacy, and we have the same difficulties in finding those in cases of collaborative creation. I think that looking at your books could also help us to try to disentangle what is happening here. So I think this is a very important book, and I'm sure that I will come back to it quite regularly. So I could have also give you some insight about French law or European law and what that joint authorship test means there, and how we could relate to your book. But this is not what I decided to do. I will try to go a bit outside of your book, and I will try to see something in your book that I really related to, and that sometimes I had a lot of questions about. So I don't know if I could fit the 1,000 questions that I have in the time that was allocated to me. So I will concentrate on a few points, and I will see how much time I have to cover those. So my principal comment actually would come from my own research. So I'm sorry to put my own research on the front here, because it's not what the event is about, but it's also because this is related to the way our paths has crossed along the years. So we met in this conference or research seminar about authorship, and I was invited there, I think, because I had written this article about authorship in a copyleft regime, and how, for me at the time, it was still open source mostly, but how those licenses were trying to put in practice the notion of authorship that was developed by Foucault, a sort of discursive practice where nobody prevails over others, but everybody share and work together and create together. So that was my entry point into the authorship debate. And then I met Daniela, and we discussed, and she talked about this issue of Wikipedia. And at the time I was preparing a research grant application, and I decided to put the case study of Wikipedia in my own research, because I was also thinking about what you told me and how inclusive it was. And my research proposal was about inclusivity or inclusive property. And so you were already, I don't know if we both of us talked about this inclusive concept, but in a way it was how we look at creation that, yes, compared to Martin and Kogan, it's not two persons working together, which is a classical case of joint authorship. But it's a bit more than that. It's where people form a community. And actually it's more, you don't only create together, you belong to a community that is creative, which is a bit different. And actually your point is to belong to that community, and then that community creates. And most of your case study reflect that completely. Maybe a bit less the film creation, but otherwise all the others is also about not only creating something and getting property rights, out of your creation, but it's belonging to a community that then would create something, and maybe the question of property right would be accessory. And for that, I think that the way you look at those case studies is really, really interesting. You really expose what is so specific in those case studies. And this is what I do also. I have this project about inclusivity where I'm trying to look not only in copyright, but I'm trying to look in patent and also in real property, how there are sometimes situations of property where actually this is not characterized by exclusivity. There is not only one single owner of a thing, but there is a community that developed something in common or managed something in common, and what it should mean normatively speaking. So what normative consequence it has. And this is my point about what you've been developing in your book, because I know that sometimes we have to limit ourselves when you are doing research, but I would be very interested in knowing what you would do. No, I will put it differently. So actually your point is to try to recalibrate the joint authorship test to make it more inclusive, to make more people count as authors, and also maybe making the community count as authors, even if it's not something that you really conclude about, but whatever. My point would be that then, for you, it's an entry point. So it's an entry point in the system of copyright. It's one who will be determined to be an author, so that he or she can enter into this ownership regime. And you're right to say that we should not conflate authorship and ownership. But then, and also because you insist quite regularly on the fact that a joint work is something greater than the sum of its parts, and I agree with you there. But then, if it is only a question of the entry point into the copyright regime, what do you do of your collaborative creation, inclusive creation afterwards? So how is it still inclusive afterwards? So how would this community of creators still exercise copyright in common? So, it's not only that they would be identified as co-authors, or how to open the lens of authorship to include them, but how at the end make that specific type of creation counts also in the way ownership is exercised. So I know that at the end of the book you say that, of course, there is a situation if we grant everybody authorship, then anyone can forbid the exploitation of the work, and there could be some hold-up situation where one co-author refuses a license, and then you say something about unreasonableness test to avoid that situation. But my point would be, would you like to go a step further and see that those type of collaborative creation, it's not only just enlarging the bottleneck of authorship, but also trying to change or subverting the copyright regime itself, so the ownership regime itself. For instance, the questions of who might have legal standing. That is a question that might be relevant for Wikipedia, for instance. In that research project, you were invited in that research project, and you discussed with us this Wikipedia case study a few years ago, and then I invited you again to another event that we organized. It was a sort of a moot where we had a fake litigation, and the litigation was Wikipedia again. And here we had a litigation where we asked some judges or some copyright experts to play the role of judges. And the cases that we had was a Wikipedia page that was the result, the outcome of many contributors. And then this Wikipedia page was copied by others without complying with the conditions of the license. So they were in a situation of copyright infringement. And the question was, how could you enforce your copyright in that Wikipedia page? Who get the legal standing? Okay, anyone? Any contributor? The contributor who put one paragraph, but actually at the time where the page was copied, that paragraph was suppressed. So was he still a co-author if actually his contribution disappeared? What about an author, a contributor that came afterwards? Does he still own something in the page, for instance? So how do you then exercise the authorship in common, and who do you still count as co-authors to give them legal standing to act if you have a copyright infringement in a Wikipedia page? I think there are more complex questions that I'm sure you are completely capable of of dealing with. So my other point is about private ordering. This is something that you briefly touch upon in your presentation, and you spend more time in the book. And I think that I was really fascinated by your insight on private ordering, because I think that you're completely right that private ordering has a lot of benefits. It could help rearrange copyright situation, it could help managing copyright in commons, but you are also very cautious in the way private ordering could also be reflective of these imbalances of power. And I think this is really important. But for that, I should say two things. For the first thing, I think that I had some reservation when you said that, for instance, Wikipedia is a successful story of private ordering. And it might be another argument, that one that I made already, is it that I don't think that of course, Wikipedia license, or the Creative Commons license that I use on Wikipedia, are really important in the way they facilitate the creative process and alleviate the issue of determining, or alleviate the issue of identifying the author to get a permission if you want to reuse that content. But they don't do anything for collaborative creation. They don't organize the collaborative authorship. They just say that everybody is a contributor. They don't even say the word author, but then they completely rely on copyright law, and they says, you know, this license is valid only if you are a copyright author. And so actually, if you have one Wikipedia pages that is written by 200 persons, your right as a user to copy that page is not a right that is given to you by one license. It is given to you by 200 licenses. So this is not what you said, you know, a joint work is greater than the sum of its parts. Actually, this private ordering is just mimicking what copyright does by just an addition of all contributors, authors, and the respective license to one word, one paragraph, one deletion, or whatever. So actually, it fragments completely the copyrighted work into this multiplicity of authors and the multiplicity of revision additions to the work. Okay, so I think that here I would like to discuss with you, because I think it's not that simple. For instance, with some friends of mine, where I've started this crazy project. Those are not lawyers, so maybe they are crazier than I am, but they are artists working with copyleft licenses for 20 years now, and they are not happy with them, because exactly that issue. They say copyleft licensing and Creative Commons particularly don't do anything for us and as artists to just convey the way we work together. And we would like to have real inclusive license that, before giving the right to use our works, would also organize the way we work together, we respect together, and we integrate each creation together. And I think this is a nice project to make those type of license that would be a real joint authorship license. So the private ordering, they would follow exactly your work. And then another point on this private ordering, and then I will be over, is on this imbalance of power. You say it quite regularly. You says that it's true that that by adopting so-called neutrality position, you could also hide some imbalances of power, and there is a hidden assumption that copyright law is completely neutral, that authorship is neutral, but by many legal tricks, actually, you might give more power to certain persons, etc. And I think that you would gain on that point, and I was looking for it in the book, you would gain a lot by reading some feminist theorists of copyright, because this is exactly what you can find in some feminist analysis of copyright law. And in all your examples, there is a lot of gender imbalance, you know, in scientific writing. We know that, of course, the director of a research lab would be most of the times a man, and he would be quoted, or he would be attributed the work among his lab researchers. In indigenous culture, it depends, but sometimes women are transmitters of knowledge, but they are not attributed because they are not recognized the status of stewards of that culture for the community. In the film industry, this is even worse. Will not elaborate on that, but even in Wikipedia, because at some point you say, okay, Wikipedia is more egalitarian. It's really not true. In Wikipedia, more than 75% of contributors are men, and they contribute for more than 90% of the inputs. And actually, when you intervene as a woman, you are excluded by different ways, so it's really not egalitarian. And also Martin and Kogan could be a really fine example for a feminist analysis, you know, where you have this behind every great man there is a woman and things like that. So, you know, I think that it would be very interesting to come back to that issue and look at it from that perspective of power and how also what you do is trying to restore some balance in that sense too. Okay, I think I will be done here.
Great. I think I better respond.
Do you want to respond first? Okay.
Yeah, I'll just take a couple of minutes to respond to some of these concerns. Probably I won't manage all of them, but we might have further discussions about it. But to leave enough time for questions, I'll try to be really brief. So Tanya, you asked about the conceptual aspect and whether or not that comes through in Martin and Kogan. And I agree that the decision is drafted in a way that it seems like that although the Court of Appeal is constantly referring to the importance of context, keeping context in mind, they don't really spell out how we work out what that context is and what we should take into account. And my suspicion is that when we get to the second part of deciding authorship shares, we are going to have to embrace the context a little bit more, because the significance of the contribution is going to matter, and the only way we can determine that is through that sort of contextual information. And you asked as well about, well, what about in this situation where we're talking about two individuals working together? I think what I see as the relevant social norms are the social norms about what makes a dramatic work, or this kind of a dramatic work, special as a dramatic work. And I think they are being taken into account when the judge really carefully looks at the significance of these particular creative choices in this particular creative context. So I think people who write films of this sort would recognize them as significant aesthetic choices. So that's the kind of social norm that I think needs to be taken into account and actually has been indirectly taken into account. But I don't know if you agree, so we can chat about that afterwards. Okay, and now I don't know if I can read all my notes. What about social norms that enshrine negative values? That was one of the questions. I think that's why the threefold filter is really important, right? So because if it is a social norm that enshrines a value that is against policy considerations because it's substantively unfair, so perhaps it's just a discriminatory norm, then I think it's a norm we should disregard. Right? So I think that there is some role for the law to take into account those questions of power imbalance by disregarding norms that enshrine those balances. And I think it's also important that we don't incorporate any norms that would take us beyond the legal standard, so that it would involve accepting a contribution that is not authorship in copyright terms. You're right that distinct was something I struggled with. And I do hedge a little bit in relation to what the meaning of distinct means. But I think when I think about it, what I really fundamentally want courts to do is to look at the reality of the objects that they are dealing with and consider how those are understood in the relevant creative context. So what's distinct should be something that is understood in the context of the collaboration. So if you think about a film, it might be that like suspenseful music is not distinct from the film, but maybe costume choice is seen as something distinct. It's separately exploitable. But there's definitely a lot more work to be done there. The outcome of Martin and Kogan, I think there are a lot of people on their edge of their seats as to what might be the outcome of Martin and Kogan. I think it'll depend a lot on the acceptance of the evidence and whether or not there is that true collaboration. But from what you can read on the Court of Appeal's judgment, I think it will be quite hard to see how you might deny joint authorship in a case where this is clearly the right kind of contribution. And if Kogan's evidence is accepted as truthful, then there's also the collaboration element there. on the question of copyright, you mentioned copyright theory. I don't have too much copyright theory. That was deliberate. It was deliberate because I was aware of the fact that we disagree, and I wanted this to be a framework that would be useful to you regardless of which theoretical position you hold. So that's why I don't commit, but I do have views.
I'm sure you have.
Yeah. I'll keep them to myself for the moment. You asked about joint ownership, and I think the question of joint ownership definitely deserves a lot more work. I end up coming down on it thinking that ultimately the law is really struggling to look at this. I look at the possibility of using a concept of a trust. I don't think that works very well. Look at the US solution where any joint owner can give a consent to a license, and I don't think that works well either. And so I really struggle to find tools that work in the law, which was why I thought we should leave it to private ordering. But I think there's a lot of space here for the imaginative work that, you know, it should be done in terms of other ways of looking at this. Wikipedia, I think I have less of a problem with the copyleft. So I have problems with copyleft licenses in general for the reasons that you've argued, I think really convincingly. But I think because Wikipedians are agreeing to a project where they renounce control, I don't worry too much about questions of copyright infringement later, because it's sort of a precondition to participation that you don't care that much about control. But I don't know if maybe we disagree.
No, we can discuss it further, but I don't think we disagree.
And I'm really, really interested in some of the feminist legal scholarship you talk about, especially the work of Keris Craig, who's written some really great stuff in that area. And I think there's a lot more work that can and should be done in that area. I'm sure I've missed a lot of this, but I hope the conversations can continue and if people have questions for any of us.
Well, I got one.
Yeah.
In intellectual property rights about jointly owned funds, I think legislators have put in rules without ever thinking what the rule should be. They have to put a rule in, so they put one in. It doesn't really matter whether it's joint owners of a patent. Some countries, any owner can license. Others, they all have to license, or it can't be done. I think actually, probably the judges can't solve this. They're in statutes, these things, and they really need a bit more thought. And one of the ways you could do it is to say, right, this is really a matter for the copyright tribunal. You need a because question of joint authorship, you're going to have people who made 10% contribution. Well, they shouldn't be able to dictate what the owner of 90 did. It may be that this is something which we ought to be thinking about in terms of a copyright tribunal solution. You might try analogies with land law. Also, the Americans tried trusts. English land law is particularly ingenious and much better than many continental land laws, precisely because you can do things with land which often get held up. And so, if you want to do something in a house in Greece, there's a second cousin in Chicago. You can't even find the writer to get his permission. But anyway, he has sentimental attachment to this because his grandfather was there. And you can't do anything. And it's quite stultifying, and it's quite important that any arrangements which the law sets up are not stultifying. And you could also find, in the case of joint authorship, the problem one says, I hate you, so I'm not licensing.
So is your question, should the Copyright Tribunal
should this be given to the
determine this?
Copyright Tribunal and watch, and the legislator should be dealing with this?
Yeah, I think that could be tricky because it could be expensive, but I do like the idea of using this provision of whether or not the consent is unreasonably withheld, because that gives you some teeth, something to kind of attack. So that's one possible solution that could be adopted, I think.
Yeah. Okay, that's
Really
lots of great stuff. What I was wondering though, picking up a comment you made, which can drive some creators nuts about the idea that reputational benefits are more important. I think the complaint that can be made is, well, you're saying we should give our stuff away for free because our reputations will all be enhanced, and that's just taking our stuff for free. But I was just sort of wondering, does authorship need to be the same for moral rights and for copyright? Like, is that something
I
you
think
sort of
so.
think about in terms of, or because if you say that there's a reputational benefit, do we say that we can have more people involved in authorship for a moral rights argument, but less for
Yeah, I
Does it need to be exactly the same thing?
So I think certainly I've read an argument along those lines, and I think that it has been argued. I personally think it's important to have a single concept of authorship because it kind of corresponds to what it is we think is the mission for copyright. And I think we need a really clear answer about who copyright protects. And if it protects these people, it should protect them in all its aspects. And I think you're right. There's a worry that if we stress too much about the importance of reputational benefits, that we sideline the importance of economic benefits, which are clearly very, very important. So I think the reputation is relevant, especially because it leads to those economic benefits. And ultimately, I'm arguing that the inclusive approach, at least, is a better shot at remuneration.
If I may, I think that as far as moral right is concerned, it comes from someone that comes from a country that is very keen on moral right. But I think that we should pay attention not to include all the reputational benefit within the moral rights sphere. Because, for instance, the attribution that we know in scientific field or on Wikipedia, it might be broader than the simple recognition of moral right, of paternity right, or, because you might be attributed without being an author. And I think that is a different notion, the attribution and the moral right of paternity. So I think and we should make the distinction also in law, because it's true that also, and it comes from also a tendency not to use the notion of paternity right because of, this not neutral gender terminology, and to replace it with attribution. And I did that too myself, but then I think that attribution might be a broader legal concept than only authorship. So, you had a question?
When Daniela smiles, she already knows what I'm going to be talking about. A few of the cases that you mentioned on the slides also are cases on implied license. That would have been the next question after joint ownership would have been addressed. So Brighton and Jones and Beckham are just a couple of examples that came to my mind. So to address partly your concern, Séverine, is the way the common law judges have dealt with this is to deal with the joint ownership aspect of it, is to rely on implied license to some extent, depending on the facts of the case. So if one of the joint authors has just not exercised or not said anything and has let the other joint authors go ahead with the exploitation, for the length of time that there was an inaction, the court has assumed that there has been an implied license, and going forward, possibly they need to all consent for future exploitation. I wonder to what extent implied license can be a response to a very large collaborative work like Wikipedia, and also in some of the other contexts like scientific collaboration, where it may or may not be that all authors are willing to just sit back and let others take charge. So there is a legal tool, but it may not be effective in every scenario. I was just wondering if you have come across any such equivalent doctrine or tool that could have been used in French law, generally in continental law.
In French law, we would need the joint consent of everybody, and we would never have recourse to an implied license. It would be outrageous for French judges. But I think that was not exactly my point. It's not that I think, but you said it very correctly in your book. You said we don't have cases that imply multiple creators collaboration. So, we still have joint authorship cases that are rather simple to deal with. And my point is just that once you have an inclusive approach where you just try to count more authors and you invite more authors at the table, it should not be for then accepting that all the authors at the table just act individually and use their exclusive power against each other, against third parties. Because if you have included them because you think that their way of collaborating is specific and is inclusive and it's, you know, where everybody is equal, or, you know, that the work is interdependent in its part, etc., then why at the end you just end up by still applying the same fragmentary, exclusionary copyright? That was my point. So, but it's true that it has this concrete application of how do you get a license then.
I think there could be a role for common design there. So, like, if there was a provision about not being able to unreasonably withhold consent, you could apply that with regards to the common design that was envisaged for that particular work at the time of, but it would be a sort of very limited way of taking into account. So I agree with you that there are serious limits there.